Good morning and welcome to the May 23rd, 2024 meeting of the City Law and Regulatory Committee meeting. I will now call the meeting to order and request the clerk to call the roll.
Vice Mayor Bernasconi.
Here.
Council Member Mendonça.
Here. At this time, I'd like to ask our Utility Government Relations Administrator, Amber Blix, to lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Amber. At this time, I'll open the meeting up to public comments. Is there any public comment? Seeing none, I will close public comment. We will move on to the first item on today's agenda, minutes from our prior meeting. Vice Mayor Bernasconi, any corrections?
No changes.
I have none either.
And we have consensus to approve the minutes.
Beautiful. Thank you. Okay, next item is our staff reports. Item 5.1, state and federal priority legislation. I'll turn it over to our Government Relations Administrator, Mark Walensky, and our our Director, right? I'm sorry, I got that wrong.
Manager.
Rob. Manager.
Yeah,
you should be Director.
Yeah, thank you.
I hereby, posthumously appoint you Director. Manager, Rob Becerra.
Good morning, Chairman Donza and Vice Mayor Bernasconi. Once again, Mark Walensky, Government Relations Administrator. And the following report includes an overview and an assortment of legislation with areas of particular focus on homelessness, public safety, building, planning, housing, campaign contributions, and at the federal level, the appropriations process and the city's recent federal advocacy trip. Joining me for the presentation is Rob Becerra, Program Manager. And at this point, I'll turn the presentation over to Rob to discuss public safety and more. Rob?
Thank you, Mark. Coming to you today with three pieces of legislation and then the request from last meeting with more information on the initiative that is moving forward that surrounds undoing some of the ramifications of Prop 47. I'll start with that initiative, which is the Homelessness, Drug Addiction, and Theft Reduction Act. Has an initiative number that is available in your council packet. The California for Safer Communities Coalition has successfully submitted over 900,000 voter signatures for the initiative, which exceeds the requirement of just about 550,000 to place it on the November 2024 general election ballot. The initiative, which has garnered support from small business owners, victims of fentanyl, social justice leaders, community organizations, elected officials, aims to address the rising issue of drug addiction and theft exacerbated by previous legislation, Prop 47. That lowered the penalties for these crimes. The initiative has three key components. One, drug and mental health treatment. Proposal mandates treatment for drug addiction with enforceable legal consequences for noncompliance, aiming to support individual recovery. Tougher laws on drug dealing. It proposes an increased penalty for drug dealers, especially those involved with fentanyl or other hard drugs, which with the provisions for murder charges if trafficking leads to death. And the third component is revising theft penalties, which the initiative seeks to reintroduce harsher penalties for repeat theft offenses, targeting smash and grab crimes, and allows for the aggregation of theft values to elevate charges to felonies. The initiative also introduces treatment mandates, which combined with judicial discretion with mandatory treatment programs will hopefully curb the cycle of drug and criminal behavior. So very interesting initiative, and it certainly hits to the heart of what Prop 47, the ramifications of what Prop 47 brought towards us. The other three pieces that I'll cover are pieces of legislation from police, fire, and building. All three pieces of legislation we're watching, but wanted to make you aware of them. First is a police-related bill by Joan Sawyer, AB 1800. This allows individuals injured by the illegal purchase of controlled substances through social media to recover damages if the platform's negligence contributed to the injury. The key provisions in this bill specifies statutory and actual damages, reasonable attorney fees, and declares the provisions servable. The government relations team watching this piece of legislation, it would be very interesting if it was put into place, potentially could have ramifications on our investigations unit to establish actual damages. There may be more burden on the police department to investigate incidents where drugs were reported to be purchased online. Second bill related to the fire department. I felt it essential that we needed to also talk about PFAS. And this fire bill, AB 2408 by Haney, is something we're watching, but it prohibits the use of firefighter personal protective equipment containing PFAS substances starting on July 1, 2026. Certainly not the correct one to speak to it, but I believe it has some fire retardant components, and that was the reason that PFAS was used in some fire equipment. This requires the sellers to notify purchasers if equipment contains PFAS and retain a copy of the notice with that equipment. Again, government relations team is watching this to see ultimate impacts of the equipment we currently have, and then, of course, the new standard for purchasing equipment in the future. And the last bill is related to our building department, AB 2427. This bill develops a model permitting checklist for best practices for curbside electric vehicle charging stations. The Governor's Office of Economic Development, or GOBIZ, will create the materials in consultation with local governments and electric vehicle service providers and utilities. The building department is watching this bill just to understand the ramifications downrange. We certainly know that electric vehicle charging stations are going to be a part of business operation throughout the city, and it's something that the building department is paying close attention to as we look to maintain them, install them, inspect them, so on and so forth. With that, I'll pass it back over to Mark.
Okay, thank you, Rob. Moving forward, with respect to bills on planning, housing, homelessness, and campaign contributions, wanted to note for the committee that tomorrow, May 24th, is the final day for bills to make it out of their house of origin. So after tomorrow, bills that haven't passed out of their house of origin, because this is the second year of the legislative session, will become failed bills. So we'll have a complete reckoning of bills next week, and we'll know which bills will remain active throughout the course of the legislative session. With respect to planning bills, Assembly Bill 2904, zoning ordinances and notice. The city has taken an opposed unless amended position on this bill. This bill would require notice of the Planning Commission's hearing on a proposed zoning ordinance or amendment to a zoning ordinance. And the city has taken an opposed unless amended position on the bill because in nearly every situation where this occurs, the applicant is the owner. Subsequently, as the applicant, they don't need a detailed notice explaining what they have asked the city to do 60 days before their own hearing. In the cases where this is a city-initiated action, staff recommends the language to be amended that a property owner shall receive a notice rather than a hearing notice. Otherwise, a situation is created where one person gets a public hearing notice 2 months before it is received by any other member of the public. This legislation, as currently written, would legitimately create an inequitable public hearing notice practice. With respect to Assembly Bill 2117, for the development of permit expirations. This bill, for purposes of determining the period of time before a variance, conditional use permit, or any other development permit or project approval is issued by a city, county, or a state would exclude the period of time during which an action or a proceeding involving the approval or conditional approval of the permit or project approval was pending. The city has taken a support position on the bill for the clarification it provides regarding the time before a permit or a project approval is issued by a city or county or state agency expires must not include the period of time during which an action or a proceeding involving the approval or conditional approval of the permit or project approval is or was pending. The bill ensures that local and state permits do not expire on an approved project while a CEQA challenge is taking place. With respect to housing, homelessness, and campaign contributions, Assembly Bill 1782, with respect to redevelopment successor agencies, existing law authorizes a housing successor agency to expend up to $250,000 per fiscal year for homeless prevention and rapid rehousing services, including the provision of a short-term or medium-term rental assistance, contributions towards the construction of local or regional homeless shelters, and housing relocation and stabilization services. The city has taken a support position on this bill for additional funding that a successor agency could spend on their low and moderate income housing asset fund on homeless prevention and rapid rehousing. Currently, successor agencies are only allowed to spend up to $250,000 per year on these services. This bill would allow cities that have available funds in this fund to provide more funding to help prevent homelessness and offer essential services to the homelessness. The city currently uses these funds toward homeless prevention and rapid rehousing. Senate Bill 914, with respect to veterans' employment, the city has taken a support position on this bill for the new option that it would provide to help veterans find employment. According to the Pew Research Center, only 1 in 4 veterans has a job lined up after leaving the armed forces. It is recognized that veterans often cite a lack of resources, underemployment, and not having a 4-year college degree as obstacles that prevent them from full employment. This bill requires CalVet to create and maintain a portal on the CalVet website with the intention of matching a veteran's military training and skills with jobs posted on the website. With respect to AB 2636, the Older California Act, the city has also taken a support position on this bill. And the position builds on the framework of the Mello Garland Older Californians Act and modernizes the act, recognizing its importance for the state and its population at all ages. It's understood that the state has an increasing population of older Californians and that the number of seniors experiencing homelessness is also on the rise. Subsequently, it's important that various statutes reflect current terms of use and are reflective of current programs meeting the needs of those aging in the state. And then finally, Senate Bill 1243, campaign contributions, agency officers. Among other requirements, the Political Reform Act of 1974 prohibits certain contributions of more than $250 to an officer of an agency by any party, participant, or party or participant's agent in a proceeding while a proceeding involving a license, permit, or other entitlement for use is pending before the agency, and for 12 months following the date a final decision is rendered in the proceeding. The city has taken a support position on this bill because it will change to a more realistic measure that would raise the threshold for contributions regulated by the Levine Act from $250 to $1,000. The measure would also extend the time allowed to cure certain violations by returning a contribution from 14 days to 30 days, and this change will ensure that the time in which a local official can cure is uniform and allow for enough time to identify and correct a contribution without being penalized. And then with respect to the federal appropriations process and a review of the federal advocacy trip, Congress is scheduled to be in session for the entire month of May before departing for the Memorial Day recess. It has a full slate of agenda items for the month, including a few of the must or should-do items that Congress must deal with before the summer recess and the general election in November. The fiscal year 2025 appropriations process will seek to advance spending bills before recessing for the summer. During this process, government relations staff will meet with the city's congressional delegation to discuss increases to the funding levels for transportation, housing, homelessness, and other areas of critical importance to the city. As we've seen in the past, Congress will very likely need to approve a short-term stopgap spending bill to continue operations of the federal government for the remainder of the year following the election. This all lines up for the next several months to be a very busy time for Congress, as lawmakers will try to complete the items of significant importance before the summer recess and the coming elections. And then finally, with as an overview of the city's federal advocacy trip, the city held its annual federal advocacy trip to Washington, D.C. the week of May 13th through the 17th. The trip provides the city with the opportunity to discuss issues, projects, and other matters that are critically important to the city and the region with members of Congress, their staff, as well as with federal agency, departments, and national organizations. During this year's trip, some of the items discussed included the city's legislative priorities on water, power, infrastructure projects, transportation, affordable housing, housing choice vouchers, veterans assistance, and clean fleet requirements. Over the course of the 3 days, we were there 5 days. It was a 5-day trip, 2 days worth of travel, 3 days worth of meetings. The city's advocacy team participated in 21 meetings with various offices such as the U.S. Environmental Protection Agency, the Federal Highway Administration, Federal Emergency Management Administration, and the Federal Energy Regulatory Commission. And you'll hear more about these meetings from Amber and Noel during their presentations. The trip allowed the city's advocacy team that included the mayor, city manager, Public Works and Electric Utilities Director, Assistant Environmental Utilities Director, Housing Manager, and Government Relations staff to advocate on behalf of our residents and business community on ways to reduce barriers to provide affordable housing, gain insight into current federal legislative opportunities, and to develop and nurture strong working relationships with the city's congressional delegation and key federal agency decision makers. Ultimately, the team gained insights into possible funding resources, recommendations on overcoming regulatory constraints, and support for various city projects. In addition, the relationships that are developed during the city's advocacy trips are an invaluable outcome of the trip and prove their importance well after the trip is completed. In conclusion, the government relations staff remains fully engaged with the state legislative process and will continue our work related to the federal appropriations process to advocate for appropriate funding levels for the various programs and services that are important to the city. This concludes our presentation, and we're prepared to answer any questions you may have.
Thank you, Mark. Thank you, Rob. Vice Mayor Bernasconi.
Yes, just a couple questions, and we might not have the answers yet, but things I would be curious in knowing once they come out. And I think this is for Rob. The Californians for Safer Communities, the kind of reform of Prop 49?
47.
47, okay. So my questions are, or just let us know when a ballot name would be identified, if there would be any opposition to it, formal opposition against the campaign or the ballot measure. And then I noticed that the city didn't have a position in it yet. Is that right?
So typically, by law, the city can't take a position on a ballot initiative. We can inform, but we can't take a formal support or opposed position on a ballot initiative.
And is that a policy that the city has?
I believe it's law.
You can go to council, though, and get a formal position from the council.
Okay.
Our legislative policy doesn't allow us to take one on a ballot measure.
Okay, all right, maybe that's something that I can talk with our city manager and Tracy about.
Yeah.
Okay. And then AB 1800, which is the social media platform, the watch position, is because, as I understand it, would want to hold the social media platform responsible for negligence. Is the watch, because that's kind of a gray area?
Yes, it's a gray area, and certainly the other side of the argument is a,
Freedom of speech and-
multi-billion-dollar, company, if it is Facebook, Twitter, Instagram, so on and so forth. So I think the watch position is, this may not be the answer to hold them responsible, but it's worth us paying attention because of potential downrange ramifications. So to answer your question and your use of the term gray area, it's a perfect example.
Okay. I think that's all I have for right now. Thank you.
Thank you. I also wanted to drill down on that social media, but Vice Mayor Bernasconi asked that, so thank you. That's going to be interesting to watch, for sure. Okay, I don't have any further questions. Thank you, gentlemen. At this time, I will open it up to public comment. Seeing none, I will close public comment, and we will move on to the next item on our agenda, which is 5.2, Electric Department Priority Legislation Update. Good morning, Amber.
Good morning, Chair Mendonça and Vice Mayor Bernasconi. Today, we wanted to give a legislative and regulatory overview of some of the state legislation that we are facing, including bills related to net energy metering, electric vehicle charging stations, distributed energy resources, or DERs, and aggregated distributed energy resources, as well as energy storage systems. And then on the regulatory front, we'll briefly discuss the California Air Resources Board Cap and Trade Program update and give a little bit of overview of our recent federal advocacy. So the first bill is AB 2619 Conley. This is now a watch bill. We did previously have an opposed position on this, and this bill would have required POUs to revise their net energy metering tariffs for eligible customer generators beginning January of 2027. This would have placed new onerous requirements on publicly owned utilities, and we worked with our trade associations to oppose this bill, and the bill is now dead since it did not meet the appropriate deadlines to be heard. So this is a good outcome and one that we no longer need to worry about. The following bill, AB 2815 by Petrie Norris, we have a watch position on this bill. This would require the California Energy Commission to provide funding to fix and replace non-operational electric vehicle charging stations that are at least 5 years old, that are installed before January 1 of 2024, and that are located in a publicly available parking space. It requires 50% of the funding designated to low-income or disadvantaged communities, and applicants must provide matching funds or in-kind contributions. So we've been watching this bill to see if there could be any potential benefits available to our community based on how the program is defined. The following bill, AB 3111 by Calderon, we have a watch position on this bill. This bill would require distributed energy resources. This bill applies to permits to install or interconnect distributed energy resources or aggregated distributed energy resources, and it would require the applicant to provide information related to the location and capacity to the California Energy Commission. It applies to mainly large customer-sited solar and customer-sited storage, and this would help monitor resources for safety, grid reliability, and effective planning. So it's really about kind of knowing where those larger resources are located on the grid and providing that information to the Energy Commission. The department will continue to monitor this bill, and this bill is moving to the second house currently. SB 1508 was another bill that we had opposed, and this bill previously focused on energy storage procurement targets for 2028, 2030, and 2035, where appropriate, and had associated reporting to the California Energy Commission. We opposed this bill unless amended and worked with our trade associations to get POUs out of the bill. The bill has since been revised to more broadly look at another topic, including modeling long-duration energy storage in the integrated resource plan process. So we have removed our opposition to this bill and are now taking a watch position. Under the regulatory items, we have the cap and trade program, and that currently what's going on is the California Air Resources Board is working on amending their cap and trade program. They recently released their standardized regulatory impact assessment, which identifies potential amendments to the program. Of importance to utilities are those kind of 3 bullets there that talk about proposed reduction in allowance allocation, the potential for full consignment of allowances, and changes to how allowance value is used. We have met with CARB along with our trade associations with the goal of minimizing impacts to POUs in the near term. This rulemaking is significant because many publicly owned utilities have made investment decisions and portfolio projections based on current program timelines and existing allowance allocations. There's a workshop scheduled next week with CARB that we are going to be participating in, and staff will continue to keep the committee apprised of any future changes to the cap and trade program as this process develops. I will note that this is on a very fast-tracked track for CARB, and they're looking at getting something in place by the end of the year. And then finally, in terms of our federal advocacy, we've had 2 recent trips for the electric department. Last month in April, the electric department participated in the annual Northern California Power Agency and Northwest Public Power Agency Federal Policy Conference in Washington, D.C. We had the opportunity to meet with several key energy agencies and our delegation in Congress. In addition, as Mark mentioned, last week, the city of Roseville had our own federal advocacy trip where several departments within the city traveled back to D.C. to discuss Roseville-specific issues. This was a great opportunity to circle back with key representatives in Congress and at the energy agencies regarding topics of importance to the city, including ongoing discussions regarding the availability of distribution transformer, as well as the California Advanced Clean Fleet rules that's affecting our medium and heavy-duty vehicles. Overall, it was a very successful trip for our team and a great opportunity to continue to advocate at the federal level. And that concludes my portion of the report.
Thank you very much. Vice Mayor Bernasconi, any questions?
Yes, I have one question for you. On AB 2015, if we can get that slide back up, that was regarding fixing or replacing charging stations. Does it go into say how they were damaged? Is that covered in this bill? You know, for example, you see things on the news lately around these EV stations intentionally are damaged. I mean, does that fall under, would that be covered?
I don't know, but that's something that I can follow up on and get back to you about. I think it's great that they're putting money towards kind of the maintenance of these things as we're looking at using them over a longer period of time. But that could certainly be something that could be of interest, as you noted.
That are vandalized, that fall under vandalism? Okay, that's all I have. Thank you.
I literally had the same question because I saw the news report in the Bay Area just day before yesterday where they had ripped off all the copper and the charging units. So I'd be interested to hear that as well.
Thank you for bringing that up.
And good news on AB 2619 that bill died. That will save us some headache for sure. All right, thank you very much. At this time, I will open it up to public comment. Seeing none, I will close public comment, and we'll move on to our next item, which is item 5.3, and we'll receive an update from our EU legislation. Good morning, Noelle.
Good morning, Chairman Donza and Vice Mayor Bernasconi. For EU's report this morning, I will be covering state legislation pertaining to ecosystem restoration, microplastics, utility service connections, and the Advanced Clean Fleet Regulation. Additionally, I will provide an update on federal legislation that we are supporting dealing with PFAS liability and the creation of a permanent low-income household water assistance program. And I will wrap up my presentation with an update on our recent federal advocacy trips. The first bill I will be briefing you on this morning is AB 2196 by Assemblymember Conley. that deals with the restoration of beaver populations in waterways. While we recognize the important role of beavers in our ecosystems, Roseville has concerns with this bill as it is currently drafted. We are supportive of the objectives of the legislation. However, the list of restoration partners does not include municipalities. Roseville has encountered issues with beavers within our creeks and has experienced direct impacts to restoration sites due to a higher beaver population within our waterways. As an example, beavers removed almost all of the cottonwood plantings that at the Roseville's Shadowbrook Restoration Project site, which was installed after a pump and lift station for the wastewater utility was installed there at that location. Roseville is working through our association seeking to include municipalities as a restoration partner. Environmental Utilities is coordinating with Government Relations Administrator Mark Wolinski and the Parks, Recreation, and Libraries Department on this measure as well. The next bill is AB 2214 by Assemblymember Bauer-Cahan, dealing with microplastics. This bill would require the Ocean Protection Council to make recommendations to the legislature on statutory changes necessary to implement their statewide microplastic strategy that was adopted back in 2022. The recommendations are to include an expansion of the statewide microbead ban to include microplastics, lots of micros in there, that are intentionally added to consumer products such as cosmetics, household and industrial detergents, and cleaning products. Additionally, the Ocean Protection Council must submit a work plan to the legislature outlining what agency will be responsible for the implementation of these recommendations. While this is directed at protection of ocean waters, the recommendations will likely have statewide impacts, so staff are watching this bill. The next bill is AB 2592 by Assemblymember Grayson. AB 2592 was yet another bill intended to encourage the development of new housing by placing limitations on the ability of local governments to collect fees to offset the costs of necessary infrastructure to mitigate the impacts of new development on the existing community and customers. This bill would have placed a requirement on water and sewer utilities to prioritize services for housing above all other types of development. This measure failed to receive a hearing by the Policy Committee deadline. Staff will continue to monitor legislation for measures that may impact Roseville's ability to adequately collect fees to offset the impacts of new development on the existing community, and that may hinder the long-term viability of a balanced and economically healthy community. The last state bill I will cover this morning is AB 2626 by Assemblymember Dixon. Wanting to build on the successful passage of AB 1594 from last year, several bills were introduced this year attempting to help local governments navigate the requirements of the recently adopted Advanced Clean Fleets regulation. Local agencies throughout California have expressed concerns with the cost to comply with the regulation, a lack of infrastructure to support this transition, and grid instability, and that there is a lack of vehicles with proven technology available in the marketplace to meet our needs. Roseville supported AB 1594 last year, which was sponsored by our trade association, CMUA. 1594 provided flexibility to public agency utilities, such as our water and electric utilities, to purchase replacements for specialized vehicles that are at the end of life when needed to maintain reliable service and respond to major foreseeable events like severe weather, wildfires, natural disasters, and physical attacks. AB 2626 would have placed limitations on the California Air Resources Board from taking enforcement actions on local governments and provided local governments more time to comply with the regulation. As Roseville continues to work with CARB on the implementation of this regulation, Roseville is also supportive of legislative efforts to help local agencies to comply with this ambitious ambitious regulation while being mindful of the cost impacts to our customers. In addition to AB 2626, 2 other measures were introduced aimed at helping local governments as well. All 3 bills failed the policy committee deadline, but Roseville will continue to monitor legislation and seek opportunities to support legislation that could help us in complying with the regulation. Shifting to federal legislation, in April, Representative Curtis introduced H.R. 7944, which seeks to reinforce the polluter pays principle within the Comprehensive Environmental Response Compensation and Liability Act, more commonly referred to as CERCLA, by explicitly providing protections for passive receivers such as water and wastewater agencies from liability. As part of Roseville's legislative platform, EU has taken a proactive approach by supporting the removal of PFAS from products where feasible, and supporting efforts to provide protections to passive receivers, such as our water and wastewater and solid waste utilities. U.S. EPA recently released a guidance document that states their intent is to go after the producers and not enforce against passive receivers. Roseville is grateful for this guidance. However, it still leaves passive receivers like our utilities susceptible to third-party lawsuits whom are not part of a settlement agreement under CERCLA. Roseville has taken a support position on this legislation. And the last federal bill is H.R. 8032 by Representative Sorensen, which is a companion to Senator Padilla's S. 3830. This bill would make permanent the 2020 Low-Income Household Water Assistance Program and provide $1.1 billion annually to fund that program. Finally, EU participated recently in 2 federal advocacy trips. The first being in April, Assistant Director Sean Bigley and Government Relations Representative Sarah Boudreau attended the Sacramento Metro Chamber's 52nd annual Capital to Capital trip in Washington, D.C. Along with 425 delegates from the Sacramento region, EU staff met with congressional administrative staff to advocate on issues pertaining to the region, which included the Sacramento Regional Water Bank, the River Arc Project, voluntary agreements, forecast-informed reservoir operations, and per and polyfluoroalkyl substances, PFAS, contamination and remediation. And then, as was mentioned previously, last week, Assistant Director Sean Bigley and myself participated in the City of Roseville's advocacy trip, where we met with U.S. EPA, the Department of Commerce, the President's Office of Management and Budget, and the House of Representatives and Senate Appropriations, and our congressional delegation. Topics of discussion included Roseville and PCWA's joint raw water conveyance project, the lead and copper rule improvements regulation, PFAS liability under CERCLA, and funding opportunities for water and wastewater facility security, as well as the solar project for our water treatment plant. And that concludes my presentation, and I'm happy to answer any questions that you may have.
Thank you very much. Vice Mayor Bernasconi?
I don't have any questions. You guys have all been really busy. Yeah, so thank you very much.
Thank you.
I don't have any questions either, but just a comment. It was nice to see on those 2 federal bills that you popped up there, the collaboration that's coming out of those. Doesn't always appear that way. It always seems like we're oftentimes fighting against them or they're fighting against us, but it was encouraging to see that that doesn't seem to be the case, at least with those 2, so that's nice. Okay, I will open it up to public comment. Seeing none, I will close public comment, and I will bring it back up to Mark for any final comments.
Final comment is, excuse me, the next L&R committee meeting is June 27th at 9 a.m.
Okay, sounds good. And I just wanted to take a moment to thank Mark and your team and all the city departments related to legislation for their recent advocacy trips and all their time and effort that they took to prepare for those and to attend those meetings and to truly lobby and represent our residents. I know that I speak not only for myself, but for my fellow council members on how much we really appreciate your efforts. We know that that is time away from your family and time away from work, and it's not always easy to navigate schedules and things on those advocacy trips, but we truly do value your efforts, and we appreciate your hard work on that, and it shows in these updates, and it shows in what happens here within our city as a result of those behind-the-scenes trips, and so your efforts don't go unnoticed, and thank you very much.
Thank you.
One thing. One thing I would like to add is, in case you hadn't heard, and I let you know this morning, Mark, that Assemblymember Joe Patterson will be presenting his resolution to name a part of I-80 after Marine Sergeant Nicole G. And as you mentioned, the House of Origin deadline is tomorrow, so there will be no special presentations, but he did ask the family if they would be on the floor this morning. It will be televised on the Assembly's website, and her family will be there, and that he's going to be making the presentation today at noon. So we'll find out what happens, but certainly a way to honor our hometown Roseville native hero, Nicole G.
And, excuse me, along those lines, excuse me, when during the advocacy trip last week, when we were meeting with the Veterans Administration, the mayor had mentioned the efforts that had gone into to honoring Nicole, and VA was very, very appreciative of that, and was very pleased to know about that, and that the city has taken those efforts, and so I wanted to share that with you as well.
Thank you.
Thank you for bringing it up, Vice Mayor. Okay, with that, we have our next date for our next meeting, which was already mentioned, June 27th, same time, same place, and we will be adjourned until then. Thank you.
Thank you.